Welcome to our session today on employing digital nomads. And this is about navigating the legal and practical considerations of what is obviously a pretty trendy subject. We've had lots of requests to cover this subject. It's having a moment, as I said. Maybe it's driven by the pandemic, recruitment and retention issues, changing attitudes to work-life balance. So obviously a lot of countries have decided that they want to welcome in so the digital nomads, as they're called. So is it as easy as it sounds? Obviously it's an attempt to try and make remote employment easier in various jurisdictions. And the question for us really is it as easy as it sounds? That's the agenda in front of you. We're going to do our best to cover the immigration dimension, the employment dimension, and the tax issues. We will not have answers for every country, I can guarantee you. We will dip our toe in the water in some specifics, but really you'll appreciate that this is very much an overview to give you a practical thought process to go through if you're considering allowing people to work nomadically, if you want to call it that. So I'll just pass on to Elaine, who's going to start with the immigration dimension.
Okay, if we could just move on to the next slide, that'd be great. Thanks, Joan. So yeah, I'm going to cover some of the key immigration considerations that businesses need to think about in relation to digital nomads. And as you can see from this slide, a number of jurisdictions have responded to the increased appetite of digital nomads to work anywhere by creating new types of visa designed to suit their needs. And these are so-called digital nomad visas. Some sources indicate there are now more than 50 countries across the world that have got specific digital nomad visas. Some of them have digital nomad in the title and they're specifically named that way. And in other cases, they might not be called digital nomad visas as such, but they are designed to suit their needs, in that an individual can work and do their, say, for example, UK job remotely from a different location, and they don't need the employer to have a corporate presence in that country for the individual to get a visa to work there. So that's one of the sort of key differences. And there are websites which have also sprung up as useful resources. So there's like Digital Nomad World, for example, which allows individuals to go on and compare and contrast all these different visas, see which is the best country for them to sort of live and work in, tells you information about cost of living in those locations, and allows people to get information about things like how to get office space, etc. And I think all of that has contributed towards this increased demand for people to want to work anywhere. And if we just take a look at the next slide, then I thought I would set out then what the difference might be between then a standard work visa and what people refer to as a digital nomad visa. So a standard work visa, the individual might do a local job. So often the employer would be sending someone overseas and they would be doing a job that was based there. The employer would usually have to have an entity, some sort of company, etc., in that location in order for the individual to get that sort of work permit. There might be a requirement to show either that the individual's got a specialist skill set or that there wasn't a resident worker available to do the job. So often there'll be some kind of resident labour market test attached to getting that visa. And it tends to specify the type of work that the individual's allowed to undertake, often for a specific employer. And in terms of duration, longer term visas wouldn't be uncommon. And if we compare and contrast that then to digital nomad visas, usually it's for someone doing their overseas job from a different location. So it's not taking up a local job. And in that sense, I guess for lots of countries, it's easier to justify giving out visas for those because they're not taking away a job from the kind of local workforce. There would be no requirement often for the employer to act as a sponsor for the individual or for them to have a corporate presence in that location. And in that sense, it's also easier for the business then. The person can work in that location without them having to have a presence there. Some visas will be conditional on the person having an overseas employer. Some of these new visa categories on the first page require the individual to use technology in the course of their job. So that's written into the rules of some of these visa schemes. And often these days, most people will be using sort of technology to do their jobs. A common trend with lots of these visas is that they are short term. So often they're up to 12 months, etc. They're not designed for people to go and sort of settle in a different country. They are to allow people to go and work from different locations on a short-term basis. And then other visa conditions are common, and you do need to check the requirements for each location, etc., to know what those are. But some common themes include some countries require you to undergo criminal record checks to get the visa. There may be a requirement for the person to have private medical insurance. They might have to evidence that they can support themselves financially, either through having certain funds in their bank account or just through demonstrating through their salary that they're not going to be a burden as such. So if we just turn to some examples, and I thought I'd pick out some examples from Europe, but also from the rest of the world. This is not comprehensive, but it just gives you a bit of a flavour about some of the digital nomad visas which are out there. So one of the high profile examples on the slide is the Spanish digital nomad visa that was introduced just recently in early 2023, and there's been quite a lot written in the press about that. And one of the perks of that visa is that it does come with a lower rate of income tax, so as a bit of an incentive for people to want to use that one. UAE is also proved to be popular, again, due to the sort of tax advantageous sort of position of working there. And UAE used to have requirements that in order to get a work permit there, you had to have a local employer that was registered there and licensed, etc. But they decided to specifically introduce this digital nomad visa that didn't require those elements in order to sort of broaden the net in terms of who could go to live and work there. And the Caribbean countries have introduced a number of digital nomad visas. In the summer of 2020, Barbados was one of the first to open its doors in sort of COVID times to remote working, and they did lots of advertising around that. Come and live on the beach and do your job from there working remotely. They did have a minimum earnings threshold, so you had to earn $50,000 or more. And you also had to have a job with an employer that was based outside the country in order to get one of these visas. But you can see why there's lots of attractions for people to want to work in one of those locations. The Estonia digital nomad visa was one of the earlier ones, again, during COVID. They were one of the first sort of countries to introduce a digital nomad visa. And again, they do have this requirement you to show that you're using telecommunications technology to get one of the visas. You must be working for a business registered outside of Estonia. It's not there if you're going to do a sort of local job for a local employer. And they have a visa of up to 1 year. So again, that sort of temporary nature of the visa. So I've shown on this slide that various different conditions can apply. There'll be various bits of paperwork that people need to get one of these types of visas. For the Maltese one, for example, you need to show some sort of lease or a place that you're going to be able to live. It is common to have to demonstrate that you can support yourself financially. And some of them do have tax perks, as I said, like the Spanish one. And some also have things like restrictions on earnings from local sources. So the Spanish one restricts your ability to earn from by contracting with local businesses, etc. So it's worth knowing the nitty-gritty of what those visa conditions are if you've got an individual who wants to go and work in one of those locations. And in many cases, a business might want local expertise, so to instruct immigration lawyers in those locations. In other cases, the business might leave it to the individual to sort out their visa. So if we just move on to the next slide. And this session today, I guess, is focused largely on facilitating employees working outside of the UK who make requests to go and work overseas. But we are sometimes asked if the UK's got a digital nomad visa itself. So we don't have a so-called digital nomad visa, but there are a number of different visas that don't require the individual to have an employer in the UK. They don't require that corporate presence, and whereby the individual can go off and apply for the visa based on their own attributes, etc., and to do a job based in a different country from the UK. I've mentioned a few different options on that slide there, but there are others. A global talent visa can be suitable for somebody working in digital technology, for example, so a software engineer or somebody like that. If they've got expertise and they can get endorsed for one of those visas, the employer doesn't have to have a base in the UK, the employer doesn't have to act as a sponsor, and they could do a job for example, a Canadian business, but based by working in the UK. The other youth mobility visa that I've mentioned up there, it's only for people of a certain age group. It's it's designed for younger people from certain countries, but allows again people to sort of move around jobs, move around and enjoy periods of holiday, etc., and working, and again doesn't require the employer to act as a sponsor and would therefore be suitable for people coming into the UK. Similarly, graduate route and high potential visas are for people who've recently graduated from universities either inside or outside of the UK. They're temporary visas and they do allow people to do remote jobs from the UK. So we do have a concept that would allow people to be digital nomads in the UK, even though those visa categories are not kind of named in that way. If we just move on, yes, to other immigration considerations. So some other things to think about if you do, as an employer, get a request for somebody who wants to do their UK job from overseas. Then digital nomads visas are unlikely to require that corporate presence. So that is likely to be a major advantage for an employer. From an administrative perspective, it's likely to be quicker to be able to get the visa because you don't need to have a base in that location. So from that perspective, it's an advantage, but you may also get requests from employees who want to go and work from a location that maybe doesn't have one of these specialist visas, but does perhaps require that element of sponsorship, etc. And if so, the employer is going to have to think about whether they do want to accommodate that request. If an individual does want to work from overseas and to do their job from elsewhere, you'll have to consider if you're going to ask the individual to deal with the visa themselves. Some sort of work anywhere policies might require the individual to sort out the visa, and in that case, we'll consider that request. Or in other cases, if it's key talent that you want to retain, you might be prepared to support the person through that process of getting a visa, etc., and doing what's needed to assist them with that. If an employee considers that they're able to work remotely on some kind of visit visa, I would say like have a bit of a red flag around that. We do hear, and lots of employees come to their employer and say, I can go and work from the US for a few weeks in the summertime and it's fine, I can do it on my sort of visit visa. And then the employer goes and checks that out and it may not turn out to be true. And the employer, even if you don't have a corporate presence there or a base in the country that they want to go and work in, it may be that you would be exposed to either criminal or civil penalties if you facilitated that arrangement and had an employee working from a country where they don't have proper permission to work. Some visit visas do allow certain business related activities. So for example, Australia, I think, does allow certain sort of digital nomad type activities under a visit visa, but I would say just be super careful about making sure the individual is doing activities that are permitted, and usually long-term working isn't permitted under a visit visa. So check if there are any right to work type compliance obligations that you've got if you're going to be arranging for someone to work for you from a different location. And in some cases, of course, individuals might ask to work, and we saw this a lot during COVID times, from a country where they actually have a passport from. So, for example, you could have an Italian employee who wants to go and work somewhere in the EU in the summer. In that case, some work anywhere policies, which we'll talk a bit about later in the session, might be more permissive of those types of arrangements. So if you're a European national and you've got a passport for there, they might facilitate people going to work remotely from those countries because it's easier from a right to work perspective. Other businesses might not want to have that sort of distinction and permit those people to do that if others are not able to work remotely. So that's just something to think about. But yeah, if somebody's got a passport for that location from an immigration perspective, that's obviously a lot more straightforward and takes one of the issues off the table in terms of the business having to think about it. So I'm just going to hand over to Joan at this point to talk about some of the employment issues.
So I've stolen my own thunder just when you thought it might be simple. Obviously, there are countries that are trying to make this more straightforward, but the difficulty for us as employment lawyers is that there isn't a marry up between simplification of employment rights and the sort of, if you like, the loosening of the red tape in relation to digital nomads in immigration terms. So at the end of the day, we will always tell you that you need to take local employment law advice. There are opportunities that you need to be aware of for employers to do what we would call forum shop. In other words, pick the court or the jurisdiction in which they are most likely to get good rights or have secure rights. And so it is relatively common for employees to acquire rights linked to the place in which the work is performed. That's true across Europe and in a number of other jurisdictions. And you might use a contract that applies the law of Scotland or England or Wales, but the employee may still be able to claim rights in the country that they work in, or in one of those jurisdictions. So I think it is not necessarily the case that we can see the two things marrying up at all. But if you go to the next slide, you'll see that the contract options are usually to do one of three things. Either you use, and I'm using this example to illustrate somebody who is currently employed by you in the UK who wants to go and work in another jurisdiction. You might do the same thing if it's somebody already in that jurisdiction who wants to work for you. You would use a UK contract supplemented by a letter that's compliant with the local employment laws for the duration of the time that they're overseas. And that would be particularly important, I think, for anybody who was there for more than 6 months. You can look at using a local contract, provided the jurisdiction allows you as a foreign employer to be party to that local contract, or you can use consultancy agreements. And the route, as I said, I'm going to keep saying this, the route you choose will depend on the local advice and other factors such as the type of work or the duration of the arrangement. You do need to be quite mindful about the benefit provision. I think Elaine was flagging it there when she was talking about it being a condition of some of the visas, because obviously these countries don't want to find themselves in a position where they have got too many extra citizens or visitors for whom they have responsibility when it comes to healthcare, for instance. So insurance, pensions, etc., all of those things effectively have to be dealt with, and you will often need to deal with those in a very local jurisdiction specific way if you've got digital nomads. What this all kind of leads to really is the question of policy development and consistency, and I think that's where we've been talking to clients most often about this. We've got more and more clients being asked to embrace these requests, and as I said at the very beginning, because we've got a bit of a retention and recruitment issue at the moment across the UK, there are organisations who are looking at it very seriously. Obviously, there's going to be benefits if you can retain key employees, but the real question for you is what governance do you put around these requests? And we saw during the pandemic, more and more people were doing these kind of on a slightly ad hoc basis, and then suddenly going, oh, what have we let ourselves in for? What have we actually, what kind of liabilities have we actually incurred as a result of agreeing to this? It's fair to say that some businesses are taking a fairly risk-based approach, so agreeing to periods of work overseas for up to a month, and then putting in a set of conditions with that, and making sure that effectively that the responsibilities with the employee to make sure those conditions are met. And I suppose some employers might go as far as to actually put almost an indemnity obligation on the employee, that the employee would bear certain costs in the event that they arise as a result of the employee's decision to go and do that. And if you go to the next slide, we're giving you a couple of examples of what you would call the work anywhere policies. So Spotify will support work from anywhere, but there are restrictions. It looks very positive on the first blush, but if you drill down, you can see where the restrictions are and why they're there. First of all, they effectively say that because of the time zone issues, they're only supported if you're sitting within the time zone region within which you're based. And they also have additional conditions. So there's they actually have a condition that Spotify has an entity in that country, which is slightly different to what we're talking about and what Elaine was talking about. But they also make it incumbent upon the individual to sort out the work permit and the visa. They, of course, also have that critical point, which is it has to make sense for the team and the role. So there has to be a business dimension to it. Google's example is a little bit more straightforward. It's 4 weeks of work from anywhere time per year in addition to their annual leave entitlements. Obviously, that's a much lighter touch in the sense of regulation. Whether that really scratches the itch of the true digital nomads, I suspect not, but it's just an example of where employers are perhaps starting to experiment with this stuff. The last point I just want to cover is in relation to what they call employer of record. you'll find that when you talk to any employment lawyers in any jurisdiction in the world at the moment, there is a bit of a sharp intake of breath when it comes to this concept. Effectively, what an employer of record does is it sets up an entity in a range of jurisdictions, usually across the world, and then they will use that entity as a vehicle through which they will employ your digital nomads. It's useful in situations, I mean, they're most commonly used actually where you've got a company that's about to set up in a new country and is sort of dipping its toe in the water, and it might use an employer of record short term because they have the payroll systems and they've got all of the setup effectively to employ people in the particular jurisdiction. So it does have that benefit, but there are some really important points that get employment lawyers vexed about this. And the first one is that does the jurisdiction permit the use of the EOR? And that's an important thing to check out properly. There's a whole question mark in some jurisdictions about whether or not these are true, they can be looked beneath. And having looked at some of the contracts that the EORs issue, I think it's fair to say that you really can't expect them to do anything else other than process the pay and regulate some of the benefits, because the contracts push all of the liability, all of the employment liabilities back onto you. And Karen's going to talk a bit about tax issues, but we're obviously always wise or live to the question of whether or not there are any tax issues arising from their use. So we have worked through with a number of companies recently the whole question of whether or not it's important to set up a local entity and what the benefits are of a local entity versus UK direct employment. I have to just tell you, it's not straightforward, but local advice is easier to get than you would think, and I'll come back to that at the end. I think that's all I have to say on the employment element of it. I'm just going to hand over to Karen, who's going to talk about tax.
Thanks, Joan. So I think it's fair to say that tax systems throughout the world are all very different, and most systems are not yet well geared up for dealing with the complexities of modern working practices of today. Each country is going to have its own set of local tax laws, which deals with the basis of how it taxes its residents and for those who are working in that country. And then that's possibly going to be overlaid with a range of double tax treaties, which that jurisdiction might have agreed with other countries. And all of those tax treaties are individually negotiated, so they're all a little bit different. That obviously presents challenges for employers who need to be able to manage the risks of unexpected tax consequences of a mobile workforce, but it also needs to be able to respond, as Joan was saying, to employees' increased desire for more flexible working arrangements. So how do we balance those? Elaine mentioned a number of formal digital nomad schemes which have been set up by different countries, and it's interesting because some of these digital nomad schemes have not actually catered specifically for tax issues that arise, although there are some countries who have now aligned their programs so they reduce the impact on personal and employer tax liabilities, either through reduced rates or compliance requirements. So Elaine mentioned Spain, which has introduced this new regime where it creates a beneficial lower tax for those digital nomads that are working there for up to a 5-year period. And Bermuda has a zero income tax regime for its digital nomad scheme. But there are a range of others that either don't have a formal digital nomad scheme or their digital nomad scheme doesn't cater specifically for tax. The UK government's also looking at what would be required to modernise the UK tax system to deal with the level of cross-border working arrangements that we're now seeing becoming commonplace. So the main 3 considerations that employers who are working out what their flexibility or policy arrangements need to cover are income tax for both the employee and the employer, what will be the deductions and reporting obligations in the host country, social security contributions, again, for both employer and employee, and finally, whether the individual's presence in a host country might actually create a risk for the company in creating a taxable presence there. So let's look at each of those individually over the next few slides. So taking the income tax risks first, there are potential considerations for both the employee and the employer. The first question that needs to be addressed is whether or not what the employee is planning on doing will actually mean that that employee ceases to be resident for tax purposes in their home jurisdictions. There are many jurisdictions, including the UK, that tax the worldwide income of their resident individuals. So therefore, if there's no cessation of residence, then the UK, for example, will continue to tax those people who are working irrespective of where they are working. So if your employee doesn't break their UK tax resident and goes off to work in another jurisdiction, they'll still be subject to PAYE in their home jurisdiction unless something else is arranged or agreed. The UK has a statutory residence test, and that's not solely based on day counting, although that is an important element of it. But other countries have different tests of when someone is resident or not, and it's quite possible to become resident in more than one country at the same time. And that's what the range of double tax treaties that these different jurisdictions have agreed are aiming to try and smooth out. And there's a few countries, the US being the most prominent example, that tax based on citizenship. So not based on your residence and not based on where you're actually carrying out work, but actually where you are a citizen. So you can see that there's a complex jigsaw of getting different countries' tax regimes to fit together when you're trying to work out what your policy arrangements should be. As well as obligations in the home country, which your employer is likely to be you as an employer are likely to be familiar with, there's also the host country's tax system to consider, and that's where things can get a little bit tricky. Most countries will try to tax work which is carried out in their territory outside of a digital nomad scheme that has a specific tax regime attached to it. And there may be some exemptions and some kind of time periods where you're able to work for a period without there being any in-country tax, but that's something that can only be looked at on a local law basis. And since double tax treaty protections often based on an individual's tax residence, you need to understand what the tax residence position is in order to work out whether these local tax obligations are actually going to kick in or not. And it's also worth pointing out that if there is an element of double tax, even if there is a relief available, there may need to be tax paid in both jurisdictions and then relief claimed in one of them, which might result in some cash flow issues for employees. And from the employer's perspective, they need to understand where their employees are, where they're working, and what their residence position is so they can work out what taxes to withhold. If you've got an employee who's actually breaking residence in the UK, then you ought to have tax compliance forms that the employee has submitted to HMRC, and the tax code should be adjusted accordingly so that you can still continue to put them through your UK payroll but not actually have to deduct any UK tax. But until the HMRC have actually changed the tax code or have agreed with the employer that they don't need to deduct UK taxes due to a double tax treaty arrangement, the employer needs to continue to deduct UK payroll taxes from any payments that are being made to your UK resident employees. Employers need to also understand if they themselves have got reporting obligations in the host country. So there might be taxes on the employee, but the employer may have to have a withholding obligation or some other reporting obligation. In the UK, you need to actually have a presence in the UK before you're going to be subject to any PAYE reporting or withholding obligations. But there are some countries, for example, Canada, where reporting obligations can arise even though there's no actual presence of the employer in that country. And so if you have an employee who's going to be taking advantage of a specific digital nomad scheme, it's definitely worth as an employer investigating what that regime means for employers, and that will be different for different jurisdictions. If we move on to the next slide, we're not going to go into the slide in terribly much detail because as well as income tax liabilities, there is a horrific set of social security implications for those workers who are moving around the world. There's a complex matrix of different laws, and they often don't follow the same principles as the income tax liabilities do. So it's quite possible that you might not have an income tax liability, but a social security obligation on the employer actually does arise. And the liabilities can be substantial. So again, local diligence is going to be key. If you've got an individual that's particularly going to be there for longer term arrangements, you need to understand how the social security implications of that country will interact with the home jurisdiction. We're lucky in the UK, it has a network of different arrangements with different jurisdictions that deal with social security or national insurance contributions. So it's likely that for short-term arrangements, UK liabilities will continue, and there ought to be an ability to avoid having to pay social security contributions in local jurisdictions, but you may have to do some compliance processing in order to get to that result. So something that needs to be investigated. Now, if we move on to the last or the corporate presence slide, this is the last piece of risk assessment that the employer needs to do, but it is an important one. So Elaine mentioned that a lot of these digital nomad schemes that are set up mean that the employer doesn't need to actually have a physical presence in the country. However, the employers do still need to think about whether there is a risk of creating a taxable presence in that country simply by virtue of an individual that they are employing working in that country. Because a taxable presence is likely to result in increased compliance for the employer. They might have to submit corporate tax returns and may well result in some tax being having to paid at a corporate level on profits generated in that presence. Or in a doomsday scenario, if it's considered that an individual is actually managing a corporate vehicle from that jurisdiction, it's possible that there might be taxable profits throughout the world arising in that jurisdiction. So it's something that does need to be considered. And that will all, again, be based on the circumstances and on the local law obligations. So you need to actually do a little bit of diligence to check to see what it is that will actually trigger a taxable presence in that particular country. But considerations are likely to include the presence of any local office, not likely to be an issue when we're looking at digital nomads, but what the actual individual is doing in that country. Are they actually binding the country in contract, their employer in contracts? Are they actually significantly negotiating binding contracts on the employer? Often companies need to take a risk-based approach to this particular issue, and it's more likely to be an issue for senior employees and for longer stays. So it might be that you frame your policies around the length of time that somebody's actually able to be in a different jurisdiction, and perhaps restricting the type of employee who actually has this flexibility to avoid any significant issues. And it's also the case, as we looked at earlier, that if you do create some form of a presence in a country, that might be sufficient to trigger employer withholding and compliance returns as well. So just onto the next slide checklist. What do we need to be thinking about? Well, we need to understand if there is a beneficial tax digital nomad scheme, does that apply for tax purposes, and what's the impact on the employer? Make sure that there is oversight on where your employees are actually physically carrying out your work, and understand where they are resident for tax purposes. And if they are abroad, make sure that you have either an understanding of the local income tax, social security and corporate presence risk, or have policies which are actually mitigating the risk in terms of the length of time you're allowing individuals to actually be working abroad from. And importantly, make sure you're continuing, if you're based in the UK and it's a UK employee, to continue UK taxes until the tax code is actually amended. Make sure that the employee is understanding that they may well be subject to double tax. There could be tax in both jurisdictions, and they may need to go through a process of reclaiming that double tax from one or other jurisdictions, and that might have an impact on their cash flow. And in framing your policies, as we mentioned, consider taking a risk-based approach. So think about the length that you're prepared to allow people to stay for, and what type of employee is going to be entitled to these policies. And also, if you know that there are countries that individuals are keen to go to that you know are particularly problematic, consider excluding certain countries from your policies. And that was all I was going to say on the tax side.
Thanks, Karen. I'm just going to finish off by highlighting a few other issues that you might need to think about. So I guess we've talked about employment, immigration and tax issues so far, but that isn't everything that an employer might need to think about if you did get a request from a digital nomad to work elsewhere. So just to run through some of these, if your business or individuals within your business are regulated, there might be additional considerations. So for example, accountants or lawyers, etc., might have professional regulators. And if they were to want to go and work in a different jurisdiction, there might be obligations to either register with regulators in those jurisdictions, or there may be an impact on the recognition of their professional qualifications if they were to practice there. So I wouldn't assume that they could practice there without jumping through some hoops. In addition, data protection is another thing to think about. If data is going to be transferred overseas, if so, what arrangements need to be put in place? Is that compliant from a UK data protection perspective? And also, are there local data protection laws to take into account? And again, local advice might be key in getting to the bottom of that. In terms of cybersecurity, you might want to think about whether your policies cover employees remote working from overseas, whether there are adequate sort of security protections in place in relation to confidential information. And then there may be additional issues like health and safety obligations locally to consider if you've got employees working remotely, even if they're home-based workers, etc. And there might be other types of compliance obligations to think about. So just to say, there's a few other things you might need to also think about. And then just to finish off very briefly with a sort of practical example, hopefully to put a little bit of colour around what we've talked about today. So if you're a UK employer, you don't have any overseas offices in this case, and a British employee who's a software engineer makes a request to work from Malta, for example, for 6 months. The employee in this case has been identified as talent. It's important for the business to retain them. And the employees become aware of the Maltese digital nomad residency permit and thinks that they may qualify. We've put up onto the slide then a range of different things that the employer would have to think about. First of all, in terms of the immigration considerations, whether what paperwork they're going to need to get that type of visa, the timing and process involved in that. In terms of employment considerations, you might want to think about whether a local Maltese employment contract is going to be needed, or if you're going to stick with a UK contract, if that's permissible in the circumstances, would certain mandatory Maltese labour laws apply, and you need to adapt what you've got in place for that period of 6 months. You might want to think about employee benefits, whether it's permissible for them to stay in your UK benefits arrangements, or whether there's restrictions around that and you're going to have to put in place local ones for that period. If you've got a work anywhere policy, how does this request fit with that? If you say yes to this individual, is that going to set a precedent in terms of other individuals asking to do the same? And if you're going to say no to anyone else, have you got a reason to justify any sort of difference in approach? Otherwise, you might run up against other employees with complaints or grievances about inconsistency. Tax implications, all of the things that Karen talked about, you're going to have to think about in that scenario. If you're going to have to take specialist tax advice, what's that going to cost and who's going to pay the costs of that? And then are there any other things to think about, like transfers of data, data protection issues, cybersecurity, other local health and safety or other obligations there? So that's a whole range of different issues you're going to have to think about in the context of that request. And I think that's the end of our session. Joan, I don't know if you're going to...
yeah, no, I was just going to... We've got there are a few questions, but I think probably the best question that's come up is from Alison Thermo Fisher, who says, is there a one-stop shop for all of this? And I think the answer is we wish there was. I think it's probably fair to say that it's a subject that I suspect quite a lot of both law firm networks, accountancy practices are looking at the moment, because it is popular. The question is whether or not, it often appears to be whether or not the costs involved in getting the policy set up and sorted out, is it proportionate to the benefit that you get? We've definitely got clients who've done it on a one-off basis because, as that previous example illustrated, you've got one key individual. It can then start to snowball, and that's then what has led to companies like Spotify, etc., really looking at it properly and deciding to implement a policy. We've got one large client who basically looked at it and said it's just too difficult, and it's too complicated. It's going to cost us too much money. So you can see that's why, where there are policies emerging, they are very short term. They've got limited countries, and I think that's the sort of the predominant theme, I think, in terms of policy development. The consistency thing is important, though, because that whole, you let so and so do it and not me. it's never good for employee relations, is it, to be in that position? And that's one of the reasons why the policy approach is so popular for international businesses. But I think it's probably a watch this space, Alison, in terms of the emergence of what you'd call products. The EORs pretend that they can do all of this, but in fact, when you get under the skin of it, they can't and they don't. So there are any other questions? I thought there's one employment question about, is it safe to assume that the employee will have employment rights in the country they're working in? It's too generic a question. I think in Europe, for instance, almost certainly yes. But if you're going to go genuinely, if you're going to create a program, you're going to need to check it out locally. And, as I said, we're part of law firm networks that can give you answers to those questions, those limited questions, fairly straightforwardly and in quite sort of an efficient manner. I don't know whether there were any questions for Elaine.
Yeah, I've got one here which is asking, so a business saying we've got lots of home workers and we found out that some employees have decided to work from overseas without asking for permission from the business. And that actually was something that was super common also during COVID. People found out that they had employees working all over the globe, sometimes for weeks and months on end without the employer having sort of granted permission, and maybe a line manager knew, but HR didn't know, and it wasn't sort of formally agreed to. And basically asking how to sort of police that. And I guess that's about communicating a clear policy to your staff. Lots of businesses have actually said maybe nothing on remote working, and people assume they can maybe tag on a period of time to a holiday and just sort of go to Spain or something and work there. So I think if the business is clear, if you do want to work from overseas, you've got to make a request, and that then leads to the question about what you do with those requests when they come in. But some form of policy around that is sensible to avoid those inadvertently employing somebody somewhere that you didn't know you had staff. And Karen, have you got any tax questions coming through?
Yeah, there's one here around, is it safer to flip employees to a contractor basis if they want to pursue a more nomadic lifestyle? I think the answer to that is not necessarily. You need to be careful, certainly from a UK perspective, if that person is effectively an employee, but just because they're providing services through a service company or on a contractor basis. In the UK, you would still need to consider if they're still resident, whether they are actually caught by the IR35 rules, and your employer obligations would still arise. And there are similar regimes throughout the world that capture this disguised employment concept. So simply flipping someone onto a contractor basis doesn't really solve the problems. And in some ways, it might make it even more complicated.
I think
one, sorry, go on, Elaine. I think I can see one more in relation to insurance,
right. Okay.
which is quite an interesting one about whether or not there's, what you do about the insurance position. I think every country, so for instance, there's an obligation for employers to carry employee liability insurance. If you have a UK only policy, the chances are it will not cover the employee abroad. There's every chance that it won't. So you will have to look at specifics of your insurance policies to check whether or not that cover continues. I'm no doubt people are trying to negotiate with the insurers to get them to extend the cover. Whether or not the insurers agree would be a whole other question, I think. That again, I'm not sort of advocating for EORs, as you probably know, but the EORs do also claim to deal with the insurance dimension. Sorry, Elaine.
No, that I was just going to say, I think we're just about out of time, but if you've asked a question we've not had a chance to answer, we can come back to you separately on that. Thanks very much, everyone.
Thanks, everybody.